It's good to get outside of Washington, D.C. and get a more balanced perspective on life. What I'm going to try to talk about is sort of the real-world role of using federal courts to advance animal interests. I'm going to talk about federal courts for two reasons. One, it's primarily what we do. We do a fair amount of litigation in state court, but the predominant kind of litigation that our firm has been involved in has been in federal courts around the country, frequently in Washington, D.C. That's becoming an increasingly inhospitable forum because of recent appointees to that court. If the election goes the way I suspect most of us don't want it to go, there's a serious question about the extent to which the federal courts will be a forum that one can seriously entertain for a lot of the issues that folks care about, and we can return to that. But the second reason I'm going to focus on federal courts is that, in fact, the federal court system does afford some substantial opportunities for people who care about animals to advance animal interests. There is no such thing as a comprehensive, strong body of animal law that is specifically designed for animals. I'm sure everybody knows that, and I know one of the panels earlier today was talking about the weaknesses in the Animal Welfare Act and the need for a private right of action to make that law even marginally effective. But notwithstanding the glaring problems and the glaring weaknesses, which we all, I think, need to work on addressing, the federal court system nonetheless does afford some substantial opportunities. What I'm going to try to do is use two, what we refer to as case studies, two concrete examples of lawsuits that our firm has been involved in, that I've personally been involved in over the last 8 or 9 years. That's going to be one of the themes, is that if you get involved in one of these cases, be prepared to stick it out for a long, long time. And in which I think it's fair to say that we did accomplish many of the objectives that we set out at the beginning, although not necessarily in the way that we thought we would, and having, I think, won some or learned some difficult lessons along the way. So I think they do both provide some good overall insights into how to approach federal litigation to help animals and what that litigation can do and what it can't do. I would actually prefer that you now let me talk uninterrupted for the next hour, although I will if necessary. I will try to leave some time at the end for questions, but I think it would certainly be a more productive discussion if there are points that I raise that while I'm talking about them you think are not clear enough, or you want to make a comment about it. So please feel free to do that as the situation arises. The two cases I'm going to talk about, and I picked what I think are reasons of contrast and comparison. One is a case that I know has been of particular concern in this part of the country, and that is the macaw whale hunt that some of you may be familiar with, and that is the Macaw Indian tribe's effort to resume whaling of gray whales after many, many years of not doing so, and the interesting legal issues that raised. And then the other issue I'm going to talk about, or case I'm going to talk about, is the problem that afflicts manatees in the state of Florida, another marine mammal much further away, in terms of the vast increase in development and specifically the impacts from boats and development projects in manatee habitat. And the reason I'm actually picking these two, other than the fact that I think they actually are pretty good stories, is that they actually involve two different kinds of problems. One is a problem that is very focused, and by that I mean there's a specific initiative undertaken by somebody. The animal community is called in to do something about it, to stop it from happening. Very particularized kind of proposal or objective which is being put forth, and it's clear what the objective on the other side is. The other side's, that is our objective, was to stop it from happening. This is the macaw whale hunt. And defining success is very simple. Either you stop it or you don't stop it. I guess there was sort of some middle ground where you can mitigate it or ameliorate it in some fashion, but from the beginning it was clear that this was a proposal that was being pushed to resume whaling, and the objective we had was to prevent that from happening. The second one is a different kind of problem, and in some respects I think a more interesting one in the sense that it was really an effort to see if one could use federal law to address a large-scale social, legal, cultural phenomenon, and that is, and I should say actually economic phenomenon, which is widespread development in the state of Florida and how that's driving species not only to extinction, but as I'll talk about in a little bit, it raises actually very substantial animal abuse issues, because that's what happens to manatees in Florida waters. So they are, in fact, abused on a daily basis. So I think they have these two different kinds of problems, and you have to look at them somewhat differently, but I think some of the lessons pertain to both as well. So what I'm going to do is talk first about the macaque case, the more sort of specific, objective situation, and then I'm going to talk about the manatee situation, and then try to draw some general inferences about what one can do with the federal court system in terms of animal protection and advancing the interests of animals. The macaque case, and some of you may be familiar, again, with some of the background of this, actually dates back to 1855. I'm not going to cover in detail every moment of that period of time. But the reason I say that is because that's the year that the Macaque Indian tribe entered into a treaty with the federal government. And like many treaties that Native Americans entered into, it wasn't particularly fair to the tribe. But it did reserve traditional hunting and fishing rights in exchange for the macaque, as was frequently the case, giving up a large amount of their territory. And what the treaty said, which has become important over the course of the litigation, was that one of the specific rights that was reserved for the tribe was the right to whaling. And the reason why it's important is because it's actually the only treaty that anybody's been able to find in which whaling was specifically reserved to the Native American tribe. There are many treaties that refer to general hunting and fishing rights, and those can encompass hunting whales as well as other species. But this was the only one that specifically referred to whaling, which the Macaque Indian tribe, when they tried to resume their whaling practice many years later, pointed to that as an important factor. But the other thing the treaty said, which was important on our side of the fence, was that these rights would be reserved in common with the tribe. That is, rights in common with the tribe and with other citizens of the state and the country. And so there was a question as to whether in common with, and I don't know how many of you have actually been exposed to treaty right language and this sort of thing, but there's a serious question as to whether in common with means that you simply can't deprive a Native American tribe of rights that others would have, or whether it provided a particular interest over and above what other citizens of the country would have. But in any event, fast forward to 1920, skip a lot of space in one fell swoop, because in 1920 is when the tribe, everybody agrees, around the 1920s, stopped to actively hunt whales. And then after a short period of time, they didn't hunt them at all for a long, long time. There's some disagreement about why exactly it is that the hunting stopped at that point. The explanations vary from the tribe's preferred explanation, which is that it was part of the U.S. government's effort at that time to civilize the tribe and to turn, quote unquote, and to turn the tribe more into a tribe that would be doing the things that the government regarded as useful and more in tune with U.S. policy. There were also some indications that over-harvesting, as it was referred to, or killing too many whales, was substantially reducing the gray whale population, and as a consequence, there just weren't enough whales to go out and hunt any longer. So it's not entirely clear what the reasons are, but there is no dispute that, in fact, in the 1920s, the tribe stopped hunting gray whales. And there's also no dispute that the gray whale population plummeted after that point, to the extent that when the Endangered Species Act was adopted, gray whales were listed as an endangered species for the first time. And also, during this period of time, the International Whaling Commission came into being in 1946. and domestic legislation was adopted that implemented the International Whaling Commission. I'm not going to go into a detailed exposition of that body, but it's basically an international treaty and an international organization that gets together every year to talk about how many whales should be killed and what kinds of protections should be imposed. It's got a lot of problems, as people may know who are familiar with that area of the law, but it will play an important role in this saga, as I'll address in a moment. In the mid-1990s, scientists began to feel that the gray whale population was recovering sufficiently to allow a hunt to proceed, to consider taking the whale off the endangered species list, and a number of entities, including the Makah tribe, petitioned the government to do just that. And in 1994, the gray whale was delisted. It no longer was protected by the Endangered Species Act. It did not take long after that occurred for the tribe to start engaging in discussions with the federal government to lay the legal groundwork for a resumption of whale hunting. The record on exactly how that came into being is, again, a little bit obscure. There are some indications that the tribe was not acting alone, that it was having contacts in particular with the Japanese, who, as people may know, for many years have been trying to substantially expand their whaling activities, particularly commercial whaling, which has always been something the Japanese and some other countries, Norway and some others, and Denmark, have done. And one of the ways that they were contemplating getting their foot in the door was to resume whaling by what was called subsistence whaling. That is, taking some tribes that could make an argument that they were engaging in subsistence whaling, and that this was a traditional kind of focus, and using that as a way of getting, as I say, a foot in the door, and expanding that once that kind of traditional whaling was allowed to take place. And sure enough, the International Whaling Commission has always had an exception for what they refer to as traditional subsistence whaling. And no one has disagreed, at least on the international scale, that in fact if there's a continuing tradition, Alaskan natives being a prime example, Russian natives being another, if there in fact there was a long-standing tradition and clear subsistence need, that in fact would be a basis on which whaling could occur under the international approval process. The problem with the Makah's case, as is readily apparent, I think, is that they hadn't whaled for 70 years. And so making an argument that this is traditional subsistence whaling is kind of a tough row to hoe, one would think. And even in terms of demonstrating subsistence need, it's a little difficult when, in fact, the tribe has been subsisting, for the last 75 years on non-whale products. Now, this didn't stop the federal government in the mid-90s. And one of the asides I would make is that there are certainly plenty of problems no matter which administration is in power. We yearn for the days when we had the headaches of the Clinton administration. But nonetheless, this was a Clinton administration initiative. And they sat down with the tribe and basically, pretty much in secret, because it took a while for people to figure out what was going on, they entered into an agreement in 1996 to actually promote the tribe's interest in resuming whaling. And they basically committed to doing a couple of things. They committed to going to the IWC and putting forth a proposal to the International Whaling Commission that the tribe be permitted to whale, notwithstanding the 70-year hiatus in whaling. The other thing they committed to doing was adopting regulations after that were to happen that would actually make clear that the tribe had a permission to resume whaling. And just to make clear that you know where I'm talking about, you guys are more familiar with this area than I am, but we're talking about the upper east-north tip of the state of Washington, which is where the Makah Indian tribe is. And there's a strait called the Strait of Juan de Fuca, which is out in that neck of the woods. And there's also the Olympic Coast National Marine Sanctuary. And in fact, this was a proposal to hunt the whales within the marine sanctuary, which is a long-standing marine sanctuary that, not surprisingly, says nothing about hunting whales and was not set up for that purpose. But that's actually the location where this was going to take place. In 1996, the federal government actually did, in fact, propose whaling for the Makah at the IWC meeting. that the proposal was withdrawn because many of the member countries, and this is not an international body which is known for its bravery and principled decision-making, but nonetheless, many of the member countries had a hard time understanding how this particular quota that was being requested could fit within subsistence traditional whaling. So as a consequence, the U.S. actually unilaterally withdrew the proposal. In 1997 is when our firm started to get involved in this issue. And again, one of the themes is going to be that if you actually have any success in these cases, you have to assume that it's going to go on for another 10 years, at least. You can lose these cases very quickly, but winning them takes a long, long time because the other side constantly comes back and figures out how to do it differently, which is what's happened in this situation. In 1997, our firm was contacted by some groups who were concerned about this, and we wrote a letter to the administrator of NOAA, which is the agency, and the National Marine Fisheries Service, which are the agencies that regulate this type of thing. And that really sort of started the whole legal ball rolling. And the letter to them basically said, we now have learned that you have entered into this agreement with the Makah tribe without telling anybody that this is what you were doing, without soliciting public involvement at all. And our primary legal hook at that point was without engaging in any analysis whatsoever under the National Environmental Policy Act, otherwise known as NEPA. And as those of you familiar with that statute know, that's a law which requires, generally speaking, the federal government, when it takes an action, adopts a rule, does lots of different things to engage in a certain amount of environmental assessment. The government, though, had not done that at all, although they had entered into a binding agreement with the Makah. About 3 weeks after we sent the letter, the head of NOAA sent a letter back to us saying, you know what, you guys are right. We did forget to do that NEPA stuff that you talked about, but it's no big problem because we're going to do it now. And sure enough, they did it incredibly rapidly. About 3 weeks later, they cranked out what's called an environmental assessment. Again, if those of you who know the NEPA process, that's sort of the first step before you do a full-fledged environmental impact statement. And it's the document you're supposed to put out to do a hard look at whether or not an EIS should be done. 3 weeks it took the federal government to crank out this draft environmental assessment addressing or purporting to address such important issues as the effect on the whale population, whether this was humane. The Makah were proposing, not surprisingly, not to hunt whales the way they used to, but this time they wanted to use 50 caliber rifles to go out and shoot the whales, as well as impacts, perhaps as importantly as all the others, in terms of precedent. One of the major arguments that we made and have continued to make to this day is if you open the door, this may not seem to many people as a big hunt, and obviously people in the location were concerned about it, but from the standpoint of the precedent would set, once you start allowing whaling on the grounds that this is a traditional subsistence whale hunt, even though it hasn't occurred for 7 decades, how many other of those kinds of activities are going to be resumed, and what kind of precedent is that going to be set for Japanese, the Norwegians, Denmark, and other countries that are looking for those kinds of opportunities. So 3 weeks later, they cranked out a draft environmental assessment for public comment. There was substantial public comment on this from scientists and others raising all of these concerns, but before the final environmental assessment was even completed, they actually made a final decision that they were going to go to the IWC once again and propose the whale hunt to the IWC. This turns out to be significant when we get back to the federal court challenge we made. But at the IWC meeting, which took place in 1997, there was once again substantial opposition from countries around the world that said, we don't see how this falls within the subsistence definition. To deal with that problem, the U.S. government, your taxpayers at work, came up with a novel solution. What they did was they went to the Russians the day before it was going to be proposed, and the Russians had traditionally gotten a quota for their whale hunting by their native Russians, because that had been going on for years and years uninterrupted. And the U.S. basically worked out a deal that they would submit a joint proposal to the IWC with the Russians, basically piggybacking on the Russian proposal. And in this way, they thought, and records we subsequently obtained showed, they could circumvent the process for demonstrating that the Makah actually fell within the subsistence whale definition. And it's not entirely clear what the Russians got out of this. It would be actually a great historical paper to figure out exactly what the Russians part of the deal was. I'm sure it was something good. But the fact of the matter is, a deal was cut, and they submitted this joint quota request. Now, what happened then was the country still had a problem with it, and as a consequence, language was derived, which has never been added to a quota in the entire history of the IWC, specifically for this situation. And what the language said was, we are giving this quota to traditional groups whose subsistence needs have been recognized. And initially said have been recognized by the IWC. Now, that would be a problem, a major problem for the Makah, because they had never recognized the Makah's treaty rights. So instead, in response to the U.S.'s pressure, they actually adopted this language, which turned out to be whose subsistence needs have been recognized, period. Language never previously been adopted by the IWC, and it left out, as the Ninth Circuit ultimately said, a very important factor, which was recognized by who? Nobody had any idea what the IWC was talking about. But of course, this did not stop the U.S. immediately after that strange language was adopted from saying, oh, of course, that was recognition of the Makah's tribal needs by either the IWC or by us or by somebody. It doesn't really matter as long as we can go out and approve the hunt, which is what they subsequently did. We filed our first lawsuit over this in 1997, arguing various things, but most importantly, that the government had run completely roughshod over the NEPA process. That by cranking out this draft environmental assessment just a few weeks after they had received our letter without taking any kind of serious look at the issues was clearly not what NEPA was all about. And one of the things that we did at the very beginning of the lawsuit, which was important, and I think this is an important sort of side lesson, is we insisted on getting the full administrative record of all of the discussions that had taken place between the U.S. delegation and their counterparts in Russia and elsewhere, as well as all of the electronic messages, all the emails that had gone back and forth, because we strongly suspected that there would be some very useful stuff in there showing the kinds of machinations they were willing to engage in to get this thing through. At the same time, our clients also did a Freedom of Information Act request to see what kinds of documents were available that way. And as a result, when the government came in and filed an administrative record that was woefully incomplete, we knew that there were many more materials, particularly emails and those kinds of supposedly confidential communications that were going to be important. Now, one of the very helpful things that happened was, some of you may know DJ Sherwood. I've worked with him over the years. He was actually working with our office at that point. And the government shipped over this big box of documents. And if you went through the documents, many of them were blacked out, as the government tends to do when they release documents to people. You may have seen these if you've done FOIA requests where you get a document and the entire thing is just like black lines on it. And then they say, here are the materials that we promised to give you. Well, DJ was quite interesting. He held his documents up to the light and realized you could read everything in the document by holding it up to the light. And sure enough, all the blacked out stuff was great. It had all the stuff about how we're trying to get around the U.S. laws, and this is our strategy with the Russians, and it was all the stuff we wanted to rely upon. So it was a little bit of an awkward situation, and if people are interested in the ethical rules that apply to this, I don't want to talk about that, but what we did was we actually wrote a letter at a certain point back to the federal government and said, now, we don't think we got a complete administrative record. We know there's FOIA documents we didn't get. And by the way, we could read through the black lines, and that stuff looks really good, and we think you should supplement the record with that. Now, they made a huge tactical mistake. Instead of writing back to us and saying, give us back our documents with the blacked out stuff, some of which, by the way, they claimed was national security material. I mean, this is even before, the Patriot Act and 9/11. So how the Makah hunt could have been, national security, we never knew. But instead of saying, give us that stuff back immediately, and we probably would have had an ethical duty to do that, instead they sort of debated us on the substance of whether or not this really was relevant to the case, which was a huge mistake because it kind of put us in the position of having to read the stuff again and say, no, it really is relevant to the case. So in any event, we wound up keeping the stuff and relying upon it heavily. So one important, I think, lesson is when you get the blacked out documents, hold them up to the light and see if you can read them. Just to kind of fast forward a little bit, we filed the lawsuit. We lost before a district court judge. We went up to the Ninth Circuit, and in the year 2000, we won a ruling from the Ninth Circuit which halted the hunt for the first time. And what that ruling said was that, sure enough, the macaque had violated the the government had violated the NEPA process by signing the contract with the macaque, the agreement, before they had done any NEPA review at all. And they said, this is not what the whole process is supposed to be about. You're actually supposed to think about what the public says and look at the comments before you sign away legal rights, before you actually commit to taking this course of action. And so they issued this rather strong opinion, which not only ruled for us, but actually put the government, for the first time as far as I know, at least in the history of Ninth Circuit jurisprudence, said if you want to go out and do the hunt again or approve the hunt again, the burden is on the government to show that it engaged in an objective, good faith analysis of these issues. We, of course, don't think they ever did that. But having won this ruling, which basically said you have to go back if you want to do this and start this NEPA process again, of course, one would have hoped that the government would have gone away at that point and not pursued this anymore, but that's not how these things go. Instead, what they did was prepare another environmental assessment in the year 2001. And not only did they prepare a new document approving this hunt, but they actually, it was kind of, and we always regarded it as kind of a slap in the face to us, saying, well, oh, you guys sued us over this? Okay, well, we'll show you. They actually expanded the hunt from the first time. What they did was, and this becomes important to the second lawsuit, they actually removed some geographical limitations that had been imposed the first time around. The first time around, they had basically said that you could only hunt further out in the Pacific Ocean and away from this Strait of Juan de Fuca. And the rationale for that was that there were these two different kinds of gray whale populations, at least we've always argued this. One is the migrating whale population that goes up and down, goes all the way from the south up to the Bering Sea. And the other population, which we've always argued existed, and the government denied, was what was referred to as a resident whale population. And these were, or summer residents. And these are whales that basically, for whatever reason, didn't like it all the way up in the north, just decided to change their practice, stopped during the summer off the Pacific coast of Washington State and just kind of hung around there and waited for the other whales to come back for the southward migration. They did the southward migration. And the first time around, they basically said that they were targeting the migrating whales because everybody agreed that there were thousands and thousands of those, but they were going to try to leave the summer residents alone because they tended to move more inshore and stay more in the strait. The second time around, after they lost before the Ninth Circuit once, they expanded the hunt. They removed the geographical limitations so the hunt could take place within the Strait of Juan de Fuca and target these resident whales, which everybody agreed is a much, much smaller population. So they did that, and they then approved the quota again. We then filed another lawsuit. We lost in the district court again, and we went back up to the Court of Appeals. In the meantime, I should say that while these things were bouncing around, one gray whale was hunted and killed by the macaque. So, in fact, during all of this, they didn't certainly get a chance to kill and take the dozens and dozens of whales they wanted, but one whale unfortunately did meet its death. We went back up to the Court of Appeals, and we won a second ruling before the Ninth Circuit Court of Appeals in December of 2002. And this time, the Ninth Circuit said two things that were actually much more sweeping rulings than the first case. And incidentally, one thing I would add is that it's clear that the Ninth Circuit was not happy with the government expanding the hunt. Well, they were engaging in this new analysis. They made a point of saying in their ruling that the government was not content even to simply go with the original proposal. And I think that had a lot of psychological effect as well as legal effect on the court. But they said two things. One was that there was a sufficient concern about the impacts of the hunt that a full environmental impact statement would be necessary. And they actually ordered the government not to go back and do another environmental assessment, to actually begin a full-fledged environmental impact statement. And they gave two reasons for that. One was the potential impact upon the local resident whales. And the court said that there is a substantial controversy that is not resolved by the record, and the controversy alone was sufficient to require an EIS. The court did not itself purport to say that there would be this impact upon the resident whales, but what it said was that we have, esteemed scientists, and we got some of the best whale experts in the world to weigh in comments and in affidavits, and they said that yes, we do think there is a resident whale population in the sense that there are the same whales that come back to the Strait of Juan de Fuca, hang around there one summer or a couple of summers, and we think this is a distinct population, and if it is, then this hunt could have a devastating effect. It could literally wipe out that resident population of whales that people enjoy for all kinds of non-lethal purposes. And we represented, in our group of plaintiffs, we had whale watching operations, we had other ecotourist kinds of operations, we had individuals who just own property and like to go out and see the whales, and they said that that could have a devastating effect not only on the whales but on the locale. And the other significant factor they pointed to was the precedent. And they specifically referred to this language that I talked about a little bit ago, this language about shall be recognized, and said because it looks like the U.S. forced through this quota in a strange way, it resulted in language which has never been attached to a quota before, and one can only imagine the precedential effects it may have in opening up new kinds of whaling where there really is not a traditional subsistence need being satisfied. So they were very concerned as well about the precedential international worldwide effects of what seemed to be a localized whale hunting operation. So they ordered an environmental impact statement to be prepared. The other part of their ruling, which is in some respects more significant than the first, and it's actually a good example of trying to use the law in a creative way, but there are all kinds of unintended consequences that can attach to that. The other part of our case was that the tribe had never gotten approval for this hunt through another statute called the Marine Mammal Protection Act. And as people here who may be familiar with that statute know, that statute imposes a general moratorium upon quote-unquote taking of marine mammals. And how it applied in a situation where a tribe was asserting a treaty right was not at all clear when we did this case. It is clear that Congress did provide for a special exception for Native Alaskan hunting, which is provided for in the statute. But in terms of treaty rights asserted by others, there was nothing in the statute that was particularly clear about that. We argued that there was general language about a moratorium, and there were general provisions in the MMPA where if somebody wants to take any marine mammal, they have to apply for a waiver, which can be granted by the federal government, but it's a very stringent, difficult process to get through. And we said they simply didn't do that in this case. The federal government's answer to that question, which turned out to be kind of an odd one, was, oh no, when there are treaty rights at stake, we don't have to do any of that stuff. Because if there are treaty rights, then abrogation principles come into play. And as people may know, when there in fact is a treaty right, and you're talking about whether a statute abrogates the treaty, that's a high standard you have to satisfy. It's very difficult to satisfy that standard. But the way we tried to recast it was, well, wait a second. You conceded when you sent that letter to us back in 1997 that you had to go through this NEPA process. You didn't come back at that point and say that NEPA was abrogated by the treaty, which in retrospect they probably should have argued. I don't know if there's anybody here from the government, but probably a mistake. But how can you distinguish complying with that statute from the MMPA, which is a statute that has its own comprehensive requirements, et cetera, et cetera? And we said it's not an abrogation situation. It's a question about whether or not applying what the Ninth Circuit and the Supreme Court have called the conservation necessity principle, which is basically kind of a principle that the courts have made up to allow general neutral statutes to be applied to Native American takings, fishing, hunting. And it's primarily been used on the state level when you're talking about fishing rights. There are a lot of cases where the question is how much of a fishing apportionment does the tribe get versus other people who want to hunt. Because if you're dealing with a common stream, obviously, if the tribe takes everything in the stream, nobody else gets any of the fish. So the question was, can that conservation necessity principle be applied at the federal level? And we had a lot of debate among our clients about whether to bring this argument, not only to make sure that it would be a good legal argument, but we were very concerned about the political implications. We fully advised our clients that we suspected that many Native American tribes, not just the Makah, wouldn't care that much about the NEPA basis for this, but would very much care about pressing this conservation necessity principle this far in a way that could, in fact, be applied to other federal statutes. And I know that one of the supposed topics we're all dealing with is cultural and social context, and this was an important one for us. But at the end of the day, our clients made the call that they wanted to pursue this MMPA argument, and I'm happy to talk a little bit about if people want to discuss this aspect of things, the role of the lawyer. I'm not saying I wouldn't have made the argument. At the end of the day, I probably would have. But the fact of the matter is, when we represent groups in these cases, even though we care about what we're doing, and unlike many of our cohorts, we're fervently interested in what we're doing, at the end of the day, we still are representing clients in a traditional attorney-client relationship. And our clients decided they wanted to press forward with this MMPA argument, recognizing there could be this backlash on a political as well as other levels. And in fact, we did that, and we won that argument in the Ninth Circuit, which turns out to be far more of a monkey wrench, I would say, in authorizing this hunt and going through the NEPA process. The NEPA process, the government cranks out an EIS, which is more involved than an EA, but they're basically done. The MMPA process is a complete can of worms that they've never gone down before if they're going to authorize this under the MMPA, which is the only thing that they can do. In any event, we won that argument in December 2002. The government and the MACA then filed one petition for rehearing, and en banc rehearing, which means asking the full Ninth Circuit to consider it. The court required us to respond to that, took another year, denied that petition for rehearing, but allowed the government and the MACA to file yet another rehearing petition, which they did. And this time they argued the whole controversy, lo and behold, had become moot in the meantime, and the whole thing should be vacated. The court came back and this past June rejected that, said no more rehearing petitions, we're done with this case. It's not moot because there's an ongoing controversy over the hunt. We assumed that the tribe, and we thought it was likely the government would file a cert petition, particularly on this conservation necessity issue. And we were kind of led to believe that would happen. It didn't. For whatever reason, and I'm hoping to find out someday, neither of them opted to seek Supreme Court review, and so that case is now done. So where we are with all that saga is that this hunt cannot proceed without a full EIS being done, and more importantly, this never-before-used MMPA waiver process. And we're trying to figure out what the MMPA waiver process would entail. It appears that they have to adopt a regulation which determines that the entire stock of gray whales can be hunted on some level. And it also seems to mean that there has to be some kind of adjudicatory hearing if that's going to be applied to the MACA situation in particular, where there can be live witnesses and all that stuff. We don't know. We're still in the process of kind of figuring that out. In the meantime, what we've basically told our clients, and I think this is an important lesson that I wanted to sort of emphasize, is that even though we've managed to keep this now at bay since 1997 or thereabouts, coming up on 8 years, and even though we've been able to resort to some pretty novel legal theories for doing that, if you want to stop this thing forever, the law can only do so much. At some point, you have to arrive at a political solution. Because many of the federal statutes, and these are no exception, give you opportunities to hold things up, to delay, to create more process. But at the end of the day, the number of federal statutes which say point blank, you can't do it, are very limited. So the only way you can effectively do this kind of litigation, if you're doing it in conjunction with an effective public education and media strategy, and using political means as well. And I'm not going to go into the details as to what a political solution could be, because I'm actually hoping that they'll do one. But whether it happens or not, I don't know. If it doesn't, then this law of unintended consequences I mentioned may come into play. In order to get the MACA this right to hunt whales, they may have to go through an MMPA process, which is not the kind of protective process it should be. That will probably turn to some extent on what the administration is going to be, who's put in these positions and makes these decisions. But every time you push the envelope, there are things that can happen at the other end, and you have to be prepared for that and deal with that. Do you have any questions about the MACA situation? Because I was going to move on to the manatee stuff, because it's actually good. Yep.
By that.
I'm sorry, can you just ask her to get it on the video?
Sure. My question was, I understand the Russian and the Japanese interest in promoting and supporting the macaw hunt, but I don't understand why the U.S. government was pushing it so hard. I don't understand what they had to gain by it.
I've ruminated about that. The documents don't make it entirely clear. I think that what they've said is that they genuinely believe that the macaw had a treaty right, and they believe that they had a trust obligation to promote the macaw's interest in whaling. And I do think if you look at the documents, there were some people in the administration at that time who genuinely took Indian treaty rights seriously. I think that was part of what was going on. I don't think that in that administration it was an effort to vastly expand whaling opportunities worldwide. At least that wasn't my sense. My cynical explanation is that it was kind of an easy, from their standpoint, it was an easy sort of gimme to the Native Americans. It's one thing to stand up for Native American rights when it involves going up against large corporations and Native American rights to stop mining or timber cutting or whatever it is. But if you could go with basically and give them this hunting right, who's going to complain other than the animal rights people and some maybe some environmentalists? I really honestly think that when they calibrate these kinds of decisions, maybe it's not cynical, maybe it's just realistic. They basically look at what kind of political grief are we going to get over this thing. And one of the admonitions, obviously, that people hear all the time is, if you don't want them to make those calculations, you have to become more effective politically. So when they look at it and they go, gee, these guys are going to be all over us, it's going to be in the newspaper, it's going to be very embarrassing. So maybe we shouldn't just look at this as an easy giveaway to the Native Americans. But that was kind of my sense of it, was that, well, we'll do this, it'll be controversial for a while, that'll die down, and we'll move on to something else. It obviously hasn't turned out that way. Now the question is, why are they continuing to do it? And I think the other important factor is inertia. Once the federal government sets its mind on something, it doesn't stop unless there's an awfully good reason for it to switch direction. I mean, it's kind of like a creature that kind of burrows ahead. And its inclination, unless there's a change in administration or some other overwhelming political reason for it not to do what it's doing, is just to keep coming back again and again. And part of that is that resources are not as much of an issue to the federal government. I mean, it's basically just going to apply the resources it wants to apply. And that's why, once again, I think if you look at these cases, you have to look at various junctures at which you can force the government to kind of rethink what it's doing. Because those opportunities don't come around that often. They come around once in a while. I think this is one of them right now for this saga. Because once they've kind of, again decided to keep going down that road, they're just not going to change their minds for another year, 2 years, 3 years. So I think inertia, sort of bureaucratic tunnel vision has had a lot to do with what they've been doing for the last 5 years or so. Yeah.
Earlier you said that the tribe may have been working with the Japanese or the Japanese with them to possibly exploit the rights. What kind of evidence did you have for that? And I guess the second thing is, as far as tribal rights go, was there any PR campaign on their behalf, in this case, against you all?
Two good questions. The first, there's not compelling evidence of that. There are some early documents which refer to contact. It's pretty clear that there were contact with the Japanese. The documents refer to meetings with the Japanese. Tribe has always said that the meetings were basically about whaling and sharing our whaling traditions and that sort of thing. Tending to be a little bit more cynical, my thinking is that was probably not the sole purpose, but part of the purpose was to talk about pursuing common objectives. And it was no secret that Japanese at that particular point in time were looking for ways to exploit weaknesses in the international moratorium on commercial whaling. By the way, there's also documents showing that the macaw clearly, when they started this whole process, did want to do commercial whaling. There's no question about that. It was on the record that they wanted to actually engage in commercial sales of whale products and that sort of thing. And then when they were told that that wasn't going to fly, then they basically said, okay, this is traditional subsistence whaling. So if you put two and two together, it appears that that's what was going on. But we never have made that a huge focus of our case because we didn't think we had strong enough evidence of that. As for the PR question, there's no doubt that they did engage in a very substantial PR battle over this. In my view, they probably won it, particularly in the Pacific Northwest. It kind of depends upon the newspaper you look at. Some of the papers in the Seattle area from the very beginning, it was just a no-brainer for them. This was clearly a Native American treaty issue. It was the crazy animal rights people coming in and telling this poor tribe that it couldn't, take a couple of whales, and how absurd that was. I wouldn't say that's for lack of trying on our side of the fence. I do think that there were very substantial efforts made, a lot of letters to the editor written, op-ed pieces done, complaints to the editorial board of the Post-Intelligencer and other folks. Could more have been done? Probably. But I think that a lot of it was the tribe did do a very good job of portraying itself as very sympathetic, because it was very sympathetic. One of the things I should say is that this is a tribe with a horrible history in terms of poverty and lack of opportunity. I mean, it's got all the traditional problems that you associate with, reservations of incredibly high poverty and unemployment, drug use, suicide, murder rates, all that stuff. And so when they came in and said, we're doing this in order to resurrect our cultural identity, and this is going to help us address these cultural problems, that resonated with many people. And one of the other points that I would stress in that regard is that, and I don't think our folks were really guilty of this, but there was a tendency in some quarters to try to demonize the tribe. How dare you guys come in and do this? This is a disgusting thing to do. I always thought that was not the most profitable way to advance the debate. I didn't think it was wise as a pragmatic matter, because I didn't think that was going to be a good PR approach. And I also thought that it was really misguided from the standpoint of working with the tribe over the long haul. And again, given the juncture we are now, whereas if there's going to be a political solution to this, and we're not going to embark on this MMPA process for 5 years, it's got to include the tribe. So I think when you're engaging in these battles, keep in mind that the people that sort of on the other side of the fence today, maybe the people you have to work with, tomorrow or next year or in 5 years. Not because you want to, but that's, a deal requires two parties to enter into the deal. But that's sort of the answer on the PR front. They did do a good job of conveying their concerns to the public. Anything else on the macaque? On the manatee issue, the reason I wanted to bring up that one again is because it's a different kind of use of the federal court system. And the problem that was presented to us, and this one also dates back to 1998, was we've got a situation, we're not talking about a particular project somewhere. We just don't, and by we I mean a combination, and I stress that because it's important to this saga, a combination of conservation and animal protection and animal rights groups. We're very concerned about the increasing death and injury of manatees in Florida waters. The reason why it was both of those kinds of groups is because this is both an endangered species conservation issue. This mortality and injury increase is threatening the manatee with extinction. But it's also an animal rights issue in the most stark sense, because manatees that survive being hit by power boats and otherwise killed by development suffer horrendous wounds. Do you guys know what manatees are, by the way? Okay. It's a marine mammal, one of the most benign creatures you could possibly imagine. And all the existing manatees reflect, or 95% of them, reflect collisions with power boats, not just once, sometimes 4 or 5 times. And in one instance, they found a living manatee that had scars of having been hit by boats 25 times and had managed to survive. So imagine, the existence that these creatures have. And that's why, again, it was a coalition of groups concerned about this from a number of different vantage points. Just to give you some idea of what we're talking about. This shows the mortality as it's gone up over the years, and other human causes that come into it. As you can see, the mortality from watercraft is literally skyrocketing over time. And from other human mortality, which includes things like getting trapped in locks, entangled in fishing gear, and that sort of thing, that stayed relatively stable, which tells you, contrary to what the boating industry claimed, that the problem was more and more boats and more development in manatee habitat, and that's really the problem. That's what was going on. And in fact, that's reflected by another chart, which again shows that boat registration is going up at the same time as manatee mortality is going through the roof over the same period of time. This is a problem that was particularly grave in some of the areas in Florida. Unfortunately, areas in Florida that have a lot of political weight, which explains some of what was going on. But just to give you some idea of what we're talking about, this is the Caloosahatchee River in Florida. All those red dots shows telemetry locations of manatees. So it just shows you how extensive the use of this river is by manatees over a particular period of time. And then you follow up from that. This is a chart or a map which shows manatee deaths in the Caloosahatchee River from boats. These are all different dates. They're a little bit hard to read on this. These are all different dates, most of which are in the past 5 to 10 years of where manatees have been found floating dead from boat strikes in the Caloosahatchee River in Florida. And for every one of these deaths, we're literally talking about 10 major wounds. So you can get some idea of what this is doing to the population of manatees in Florida. And the other thing I would say about that information is that it's a huge underestimate of the problem because there are many, many undetermined, quote-unquote, manatee deaths and injuries, which appear, from our vantage point, to be result of boat strikes, but are not definitive enough for the state to make this finding. There are also a lot of what are called perinatal deaths, which are manatees that are only 6 months, 3 months old, found dead, and it's very hard to determine the reasons that they've died. But scientists say that many times it's because the mother's been killed as a result of the boat strike, and as a result of the babies die as well. So this is the problem that was presented to us, along with general habitat destruction and degradation. And we were asked to figure out a way of doing something about that. And what we did was sit down and try to look at all of the different laws that could be brought to bear on what seemed to be an insurmountable, monumental problem, which is literally doing something about greed in the state of Florida. Not an easy task by any means. But to think of any, seen the John Sayles movie, Sunshine State, you get some idea of what we're dealing with on this situation. But we did a Freedom of Information Act request to get all the documents that have been generated by the federal government in improving projects in the state of Florida over the last 5 or 10 years. And this is principally problems approved by the Army Corps of Engineers and by the United States Fish and Wildlife Service, because every time you build a dock or a marina, this is true every place, the Corps has to weigh in and give its approval to that. But one of the things we realized was that they never looked at the cumulative effects of approving thousands and thousands of these projects every single year. They literally put on the blinders, and every time they would look at the effect of a project that was going to add 5 more boats or 10 more boats to a waterway, that's all they would look at. And they would say, I wish I were making this up, but I'm not. They would say, well, adding these 5 boats is not going to be a problem. We've already got 70,000 boats out there. And that's what they'd say the next time. And they'd never stop and say, but yeah, we're the ones who approved the other 70,000 boats. Maybe we've got a cumulative problem that we should do something about. Never did that kind of analysis. So we thought that that was a violation of federal laws, including NEPA and the Endangered Species Act. And the other thing that they had never done was they never once again complied with the Marine Mammal Protection Act process for approving activities that result in take of manatees. And because the manatees are an endangered species, you're not allowed to approve take under the Endangered Species Act unless you also have regulations that have been issued under the Marine Mammal Protection Act. So to make a long story shorter, we filed a lawsuit in the year 2000 basically challenging the entire federal process for approving new projects in the state of Florida, and said that this was a massive violation of federal laws because all of these increases in death and injury were going on. Our claims were a little bit more refined than that, but that's basically what it boiled down to. And as you might imagine, this basically served as a magnet for virtually every economic interest in the state. We got intervention requests from the home builders in the state, from the watercraft manufacturers, from the boating industry. They all came in to our case. And then to get the government's attention, because we filed our lawsuit and a couple months later, they were still issuing permit after permit. We filed the motion for a preliminary injunction to halt permitting of new projects in about half the state of Florida. That did get the federal government's attention. And they entered into an arrangement where they severely limited that while we then embarked on 9 months of settlement negotiations. And literally, it was 9 months of sitting across a table with a representative of the Justice Department, as well as some lawyers from big law firms in Washington representing every industry group imaginable. And the objective was to see if we could come up with an agreement that we could hammer out. Now, we were helped by the fact that we had an excellent district court judge who had made clear that he wanted us to reach a resolution. He also assigned a magistrate who was tremendous to help us do that. But at the end of the day, and the politics may have helped us too, because we signed an agreement and filed it in January 2001. The waiting days of the Clinton administration, and as you may remember, the Clinton administration actually did some useful stuff in its waning days. It's not entirely clear what it did for its first X number of years, but its waning days it actually did some useful things. And it entered into this rather far-reaching settlement agreement, which committed the government to establishing new refuges and sanctuaries for manatees throughout Peninsula Florida, as well as new restrictions on permitting projects, cumulative impacts analysis for the first time, putting out a new recovery plan for the species, and a host of other things that, if actually done the way the settlement provided, would really have been a sea change, no pun intended, in how this was all going to be done. Now, the Bush administration came in, and so it wasn't done the way one intended it or hoped that it would be done. In fact, no sooner did we sign the settlement agreement than the Bush administration, which came into office literally a few weeks after we signed it, started to violate the agreement, including the plain terms of the agreement. And just to give one example of what they did, they immediately announced that they didn't feel that they were obligated to actually adopt these refuges and sanctuaries, which they had committed to adopting. And just to give you some idea of what that entailed, this is from the federal government's own list of where they had decided were considered to be high priority emerging sanctuaries and refuge sites. You guys are familiar with the state of Florida. That makes up a large part of the state of Florida because that's where there were mortality and injuries going on throughout the state. The federal government, when the Bush administration came in, announced that, lo and behold, it thought the state, and as you may know, the president's brother was the governor of the state, which is actually quite pertinent to this story because there were a lot of contacts going on, announced that, no, we think this is a state issue. We think the state is actually taking ownership of the manatee problem, and we think we can defer to the state on this one. So we're going to go from these 65 or whatever high priority sites to nothing. We're not going to do any at all while we wait to see what the state does. We didn't think that was what our settlement provided for, and so we actually went back to the judge and filed a motion to compel compliance with our settlement agreement, which the judge granted, and then asked us what kind of remedy there should be for the violation and told the government to tell that as well. The government's remedy was to declare the settlement unconstitutional. Again, I'm not making this up. As they said, it was unconstitutional because if, in fact, it committed them to doing anything, that was an infringement on executive power and therefore unconstitutional. And they said, but if we are required to adopt any actual refuges and sanctuaries, make us do that in December 2002. Now, that's an important date if you remember the history because November 2002 is when Jeb Bush was running for re-election. And they literally, and the documents show this, they literally wanted to put this off until after the Florida governor's race because this had become a fairly hot potato in Florida state politics at that point in time. Well, fortunately, Judge Sullivan was having none of it, and we had a hearing which was actually particularly humorous, and actually I've got a transcript because it's actually a good example for those of you guys who are would-be or existing litigators, because it's great when you sit back and watch the other side take aim at their foot and shoot as much as they possibly can. And in this particular situation, I came up, and I was hoping to have, but I couldn't bring it out here. I had a blow-up of a manatee that had been sliced and diced by boat traffic, and it was like these classic pictures of manatees with like 9 different, boat strikes on its body, horrible wounds. And I said, here's a typical photo of a manatee that's been scarred not once but repeatedly by propellers. At which point the Justice Department lawyer said, Your Honor, I would object. We're offering evidence. It's inflammatory. Saying this to a federal judge, keep in mind. It's not a jury trial. It's not relevant. It's a picture of a manatee being hit by a propeller. What relevance does that have to the issue before the court? Judge Sullivan, that's what this lawsuit is about, sir. Mr. Hedenbach, the Justice Department lawyer, I understand the court. It's about saving manatees from this type of occurrence. and the courts go, it's highly relevant and talks about how horrible it is, in this case is about saving manatees. So when that happens, you kind of just sit there and thank your lucky stars. And it was not long after that that Judge Sullivan not only ruled that they had violated the settlement, but he ordered Gail Norton, the Secretary of the Interior, to show why she should not be held in contempt as the head of the Interior Department for what were massive violations of the court-ordered settlement agreement. We then used that in order to sit down with the government again, and this time they had an Assistant Secretary of the Interior personally negotiating a supplement to the settlement to get out of the contempt hearing. And they agreed to actually adopt refuge and sanctuaries in a number of other places, including the Caloosahatchee River. For the first time, the federal government adopted a speed zone in the Caloosahatchee, the map I just showed you. It wasn't as good as one we would like, but it was certainly almost difficult for us to believe that the Bush administration would do that, and they did it solely because they had a contempt proceeding that they were trying to get out of. We're still having problems with settlement compliance, but we've at least gotten over that hump. But once again, in terms of the law of unintended consequences, because they don't like the legal underpinnings of the lawsuit, the Florida Marine contractors have gone to Capitol Hill and have gotten a House committee run by Mr. Pombo, some of you may know him, to consider legislation that would exempt manatees from the Marine Mammal Protection Act. I'm not kidding. I mean, it sort of is done slightly more cleverly than that, but that's basically the upshot of it, as well as all other endangered species would no longer be covered by the MMPA. And so they've started that process on the Hill, and I wouldn't say it's impossible that it happened, given, especially if the political context stays roughly what it is today. They've also filed 2 lawsuits in the state of Florida, one of which is again designed to have a federal judge declare that the MMPA does not protect what are called inland waters. And they have this very convoluted legal argument, but their argument basically would exclude all of manatee habitat from the coverage of the MMPA on the grounds that the MMPA only covers waters that are in the ocean and outward, and not any rivers or streams or lakes or any of the places that manatees actually survive. So there's been this counter-attack, which is basically going on as well, and there's been a lot of back and forth. I'd say on this one, overall, the public education campaign has worked effectively, and we've done a good job, or my clients have done a good job, of really explaining the plight of the species and getting out in front on the public education debate. And I think that's helped drive things considerably, during the process. I think during the course of this, I've pretty much summarized what I think are some themes of doing this kind of work. But just very quickly, if you're going to do it, you better prepare to do it for many years. You can't embark on one of these cases and think it's going to be over in 6 months to a year and it's going to be done. Any of you who have done anything in this area or environmental law know that that's the case. If you're successful, it's a long, long battle, and you better be prepared for that, both in terms of your personal stamina, the resources available to you, what your groups are aware of, et cetera. Secondly, and I think picking up on the good question, litigation can be a very important part of the battle, but it can't be the only part of the battle. You cannot bring these cases and be successful unless you're also prepared to bring to bear public education, media interest, political efforts, and the entire range of weapons for advancing public debates. And along those lines, if you just bring a lawsuit and don't have those things ready to go, you're setting yourself up for disaster, because it's almost invariably not going to work out the way that you want. The third overall point is that broad coalitions are better than narrow ones, by and large. In the manatee debate, it turned out to be very helpful that we had both conservation groups and animal protection and animal rights groups, because when there was debate about the population status and all that stuff, we could say, well, yeah, but even if it's not clear what's happening with the population, is it still okay to have manatees treated in this horrible way? Are you saying it's acceptable to have manatees around that are suffering these kinds of injuries? And it was very helpful to have that kind of a coalition. And the fourth lesson is learn how to use all the tools at one's disposal. Since there is no general legal infrastructure for protecting animal rights, you have to use what's out there. And that means the Freedom of Information Act, Administrative Procedure Act, MMPA, NEPA, Endangered Species Act, a whole range of laws that were not specifically designed to protect animals but can be used in that way. And the fifth overall point is get to know experts, scientific experts, and use them. In all of these debates, the experts have been critical because they give the case credibility, And sometimes it's difficult, but you really need to bring those people to bear because judges respect them. And it shows that your case is sufficiently credible to attract that kind of attention. So that's my summary of the manatee, and I wanted to at least leave some more time for any questions about that or general sort of topics of discussion that people may have.
Just wanted to ask a question on one of the last things you said about the role of science in some of these battles. Did the government bring in their own scientists, and what do you think of that kind of battle, and how detailed it can get, and how complicated and confusing, and how are there really real answers out there?
The government obviously has its own people that it frequently has on staff, and it uses them. It could also bring in other people, and it does. And this becomes a big problem because frequently scientists are not the most, I don't want to say courageous, but they see their role as a somewhat different role. They tend to shy away from controversy. They tend to not want to weigh in unless they think the science is absolutely clear-cut, and the science is rarely absolutely clear-cut. And they frequently depend upon the largesse of the federal government for grants, for general relationships, credibility. So it's not an easy thing, and that's why I think it's worth stressing. I think one of the things you have to do is learn who the scientists are who are willing to kind of buck all that. And sometimes it's actually the best scientists in the world because they have nothing to lose. I mean, in the macaque case, we got this guy, Jim Darling, who some of you may have heard of, who is a very recognized gray whale and general whale expert. And basically, he's somebody who's been around for a long time, has a tenured faculty position. He doesn't really have to worry about what anybody's going to do to him. So it's frequently people at that end of the spectrum or people just starting out who haven't learned yet, that they should worry about that stuff. My experience has been it's kind of the people in the middle of the spectrum who have gotten enough credibility, but they're still a little worried about their position. But if it turns into a pure battle of experts, you're going to lose. I mean, if the case becomes, our experts better than theirs, you're going to lose, which is why you're not getting experts to show the court that your science is better than their science. What you're doing is saying, we've got strong legal arguments. And by the way, in addition to that, we're not off the wall from the standpoint of what the science in the real world is all about. So it's really just to give a court who might be inclined to rule for you on the law that there's enough of a reason to go along with you. I mean, in some cases, like Section 9, taking claim under the Endangered Species Act, it has to be a battle of the experts. But in many of these administrative law cases, it's really to show a court that your legal arguments are sufficiently meritorious. So it's something you just have to work at. Yeah. Sorry, should have gone with you.
I noticed that in the second case there was a settlement, but in the macaw whaling case there wasn't. Why was that? But you didn't even mention settlement.
Yeah, I'm glad you pointed that out because I actually was going to say that. Different cases can be settled. Some cases can be settled and some can't. My view is that one should always explore settlement possibilities because you could frequently get more out of a settlement than you can out of litigating the case. In the manatee situation, some of the relief that we received that the government gave us was relief we could probably never have gotten a court to order. The judges are frequently locked in many ways to issuing injunctions and those kinds of things. But more creative sorts of remedies you can get through a settlement. I think in the manatee situation, we were benefited by having an administration that when we presented them the arguments, A, realized that we had strong legal arguments, and B, wanted to do something. I mean, that's what I've been told by Clinton administration officials afterwards. That they looked at this and they said, we should be able to do something more for the manatee. We agree that there's a problem. And so I think that had a lot to do with it. I think they really did want to come to a solution. And then the question was, what could it be? And that goes back to the nature of the problem. When you have something which is very broad-based, like the manatee problem, that's part of the problem in terms of getting your handle on it legally. But actually, in some ways, it helps from a settlement front, because if it's that sort of diffuse, then you could sit down and have more flexibility. The macaque
that actually did the research, that figured out the statistics and did their tests and examined the data and turned out
to be able to prove that something is so. And very impressive. You don't see that often in lawyers at all. Because they're filled with rhetoric. That's all lawyers are. It's just a bunch of rhetoric. And to see that someone actually has spent an enormous amount of time and energy putting together that thing was just very admirable. I'm going to do something a little different, which is I'm going to deliver a talk. I tend to, when I write, be fairly careful about what it is I choose to say, and then when I speak, which is quite often, I tend to end up with an article out of the thing, and sometimes the article and the speech are kind of connected together. And even though, as when I teach the class, I just get a yak for 45 minutes and riff on all sorts of fascinating things that I make up, it turns out a little bit easier on me both when I write and when I have a topic that's pretty important to me that I specifically read it. And so without actually reading too much to, I'm going to deliver this talk to. Considering that it's getting somewhat close to Halloween, close enough for me and my family anyway, I thought it'd be appropriate to address some of the spookier issues in animal law, and I hope to not frighten too many people. But I've selected one that personally gives me the most chills in my practice. As Holly said, I'm an animal law attorney. Laura Ireland and I run lots of animal law cases, including lots of veterinary malpractice cases. We plaintiff and defend all sorts of things, and we come across not just a variety of clients and defendants and pet owners and pet problems and animal problems, but we come across a variety of legal issues and questions, and one of the worst and most chilling to my blood is who owns the dog. And I know it doesn't sound like it's that spooky to you, but it makes me often think of ownership issues, which is a interesting area for me to both write and think about, and because I have to deal with it on one level, at the trial level, I'm not bottom-up kind of guy. I do not deal with legislation or legislators, or I deal with statutes when I have to, but primarily what I do is trial work. What I try and have happen is trial judges and juries to issue orders or rulings or verdicts, and then from there see if I can change the common law or common law interpretation. So to do that, I have to deal with who owns the dog in trying to come up with what the test is in Oregon, which you'll find is a very odd test, and what the test is elsewhere, which is something that trial attorneys have to do, is compare jurisdictions and convince 12 people sometimes, or a judge sometimes, or a three-judge panel sometimes, as to who the dog owner is. And the more I delve into it on a case law basis, the more I find that it is very, very spooky. I'm going to scare you a little bit then by telling you this terrifying story. I've called it the Scooby-Doo effect and the phantom of animal ownership. Small children may wish to leave the room at this point. Okay. I'll start with a not-so-scary example in comparison to keep it a little tame. There's a business entity called the International Star Registry. I don't know if you know about it. You can buy a star and name it after a person. Someone's nodding their head. And for $50, you get a very nice gold certificate that says you are the owner of that star. There's no exclusivity at all to that purchase. As you can imagine, you certainly can't possess what you bought in the sense that you can with any other purchase objects. You certainly can't restrict another's use to it or enjoy it only to your exclusive use. You can't even stop someone else from renaming the star after somebody else. You can't prevent other people's manipulation of what you think your ownership attributes are. And you certainly can't derive any real financial or utilitarian value out of calling yourself the owner. Because of the nature of what stars actually are, ownership rights in stars are entirely illusory. They're entirely artificial. Now, indeed, the registry I mentioned is not so much of a star registry as it is a sucker registry. It's what really registers isn't stars, but people. People who are willing to give money to other people for having their name written down on a piece of nice parchment. That's what it registers. The star registry is a consumer phenomena. It exemplifies the invisible hand of the marketplace in showing the bright and shiny ways that we can siphon off the money from the rich by using different colored pieces of paper. That pretty much is what it exemplifies. For a number of reasons, there are no formal laws prohibiting the buying and selling of stars other than unfair business practices laws prohibiting false advertising. Now, on the other hand, there is, as far as I can tell, no international ant registry where you can purchase an ant and name an ant and get a gold embossed certificate about your ant. Entomologists estimate that there are probably about 1 quadrillion ants in the world at any given time. That would be a 1 with 15 zeros after it. So it certainly isn't a matter of a supply shortage. Lack of a registry is not based on any concerns about how many ants there are to have. There's plenty. Moreover, a quick glance at eBay indicates that there's probably no shortage of suckers, people, who are willing to buy ants, probably. And finally, the characteristics between and among all the ants in the world are probably about as negligible as are the characteristics of all the stars above the world. And so it certainly doesn't seem to be any sort of distinctive individual characteristics about ants that make the lack of a registry apparent either. And yet, ants are treated quite differently than stars are in the way that the law considers them as legal objects. I'm not going to speak down to you in a sense. There's both students and lawyers here, but we're going to have to start from some basis of knowledge, and so we're going to work only in this talk anyway, in what the law is interested in. Not codified law, as I told my proclivities earlier, but the common law. The common law memorializes the historical understanding that people can own animals and do, a group of which ants are definitely a part, and it allows people to assert ownership rights in animals to their personal benefit and to the detriment of others. The stars versus ants example tells us at least this to begin with. Even with fairly silly animals, ownership rights in animals are real legal constructs. They are not illusory and they're not artificial. And they all begin with the putative owner having to actually do something, take certain steps to become an owner. So, what is it that the owner actually has to do? That's what we're going to talk about. Well, for one thing, to become an animal owner, you must first wrestle physical control of the animal away from everybody else in their public form known as the state. You can't just register an ant and thereby become an owner. You have to go out into the wild and capture an ant. Here's a quote from a very recent case. Most of my case sites are going to be from 2002 on, except for one. And here it is explaining the rules. A wild animal, fera naturae, for Latin lovers, as opposed to a domesticated animal, domita naturae, is owned by the state or the people at large. An individual does not acquire property rights in an animal fera naturae as long as the animal remains wild, unconfined, and undomesticated. Even a landowner does not acquire property rights to the wild animals naturally existing on his or her land unless they are reduced to actual possession and control. That's Booth versus State, Arizona, 2002. I gave you in my handout, I think, in the book, I gave you the site. So, very recent case. Arizona is not setting the rule, it's the rule throughout the union. Actual possession and control, you have to reduce it by grabbing it away from the state and taking whatever manifestations that animal has and bringing it into yourself. You cloak yourself with a number of things. The Booth case is reiterating a very archaic rule, one that has remained a rule for a very long time. 200 years ago, the law accepted that if it was in your interest to try to kill some living wild thing, and you were pretty good at it, and you would be assumed to have succeeded in being its owner, or at least the owner of what was left after you had mortally wounded it. Although the rule itself predated the 19th century by quite a bit, most lawyers know it from its articulation in an 1805 case. I'm sure Holly will be very excited to hear. Pearson v. Post. You hear it in law school, you know it well, but how often does it come back to haunt you in your everyday practice? Well, my practice haunts me every day. In fact, it makes me have to read you the relevant part of Pearson v. Post too, so we can remember just what spooky things we're going to be talking about. The mortal wounding of such beasts by one not abandoning his pursuit may, with the utmost propriety, be deemed possession of him, since thereby the pursuer manifests an unequivocal intention of appropriating the animal to his individual use, has deprived him of his natural liberty, and brought him within his certain control. The possession of beasts. I gave you the Pearson v. Post citation in the back of the thing. 1805, the possession of beasts. Okay, now things are starting to sound a little bit spookier. As primitive and historically distant as it sounds, the rule in Pearson v. Post haunts us nearly every day. We reduce to our actual possession and control tens of thousands of wild animals over the course of our lifetimes. Now, mostly they're bugs and mosquitoes and ants and flies, but the fact that they aren't very likable and the fact that they aren't very big doesn't change any of the rules. The fact is, they are animals, they were wild. The state owned them, we did pursue and mortally wound them, and we did subsequently own them ourselves under Pearson v. Post, because we took the time and the effort to deprive them of their natural liberty. So what if our weapon was a fly swatter or a shoot, or our hunting ground happened to be our kitchen or our front porch? Or so what if we decided to fold up our hard-earned possession into a napkin and throw it into the trash? That doesn't change the rules either. For innumerable brief moments throughout your lives, we are all wild animal owners. Don't let anyone tell you any different. Now, some types of wild animals that we take the time to reduce to actual possession or control, we value slightly higher than others. One category of those animals is domesticated animals. We haven't domesticated mosquitoes, flies, or ants just yet, but we have domesticated dogs, and even though we become their owners in the same Pearson v. Post manner that I just explained, we give a certain significance to the dogs that distinguishes them from other animals, especially from ants. Never forget, of course, that all dogs are certainly deprived of their natural liberty and subject to social control by the state. 200 years of common law interpretations of Pearson v. Post have confirmed this over and over again. Our boast is we can pretty much do anything we want to with dogs as long as the state approves. You don't believe me? There's a recent New York slip opinion. States the idea very nicely, 2002, New York. I list the site for you in your materials, Johnson versus Center for Animal Care and Control. Property in dogs is of an imperfect or qualified nature, and they may be subjected to peculiar and drastic police regulations by the state without depriving their owners of any federal right. Dogs hold their lives at the will of the legislature, are subject to the police power of the state, and might be destroyed or otherwise dealt with, as in the judgment of the legislature, is necessary for the protection of its citizens. Here the defendant seeks only to neuter these animals. However, legislatively mandated actions of an even more drastic nature have been endorsed by our courts. Thus, a statute authorizing the destruction of all untagged dogs found outside their enclosures, even with notice of their ownership, held to be a valid police regulation. 2002 rule, again, New York's not setting the tone for anything. They're simply reiterating what Pearson has said for us for a couple centuries now, which is we can do what we will with dogs as long as enough of us agree to do it. And it seems to be including not just neutering, but destroying and impounding and all sorts of things. Okay, so we can capture and confine and control and possess dogs, and we do it all the time. Still, not so spooky, not so unusual. It's when we get down to the bare bones of which one of us specifically owns which dog. That's where the rules have been eerily changing. And that's the ones that are currently being worked afresh by animal law attorneys, clamoring for a recognition of this special relationship between dogs and their owners. Now, keep in mind that we recognize, as to other properties, whether personal properties such as cars or real properties such as houses, that there are socially and legally approved indicia of ownership. For one thing, owners of these objects possess a title, as with a car, or a deed, as with a house. That, as a formal document, reflects some sort of manner of purchase or an exchange of the object from one person to another for consideration. There is no pursuing, capturing, and appropriating houses and cars, other than inner city Chicago, perhaps, and that sit in rust or go up in flames. It doesn't really matter what you do with the house or the car. As long as your name is on that formal document, you remain the owner. Your actions as to the property doesn't matter. And no formal documents go along with the ownership of the dog, as you know. As far as the common law is concerned, no formal documents at all. Sure, you may have in your hands a purchase invoice from Petco, or a vet record from an animal hospital, or an AKC registration paper, or a blue ribbon from a pet show, or a photograph of you actually delivering the dog at its whelping from the mother. Any number of legally looking pieces of paper that might seem to indicate your exclusive ownership. But none of them are dispositive of ownership. Legally, they're all merely indicia of ownership. Big difference to us lawyers. Indeed, the common law says, well, at least with horses and cows, but I don't think it's too exclusive, even an actual brand or a mark of your name on the animal is not indication of ownership either in an evidentiary sense. It's only proof of identity of the animal. That rule hasn't changed either. It's at least a century old, and it's not about to change. Welch versus State, Texas rule from 1900 hasn't changed. For another thing, with property such as cars and houses, the transactions conveying those things between people rely on the existence of a market between them. I don't know that you've ever read anything I've ever written, but I seem to have this abnormal fixation on the valuation of animals and the market price and the market valuation of animals. We feel comfortable using financial documents that reflect the value of a house or a car to other consumers in the marketplace. That seems to be proof of valid ownership along with the deed or the title. With animals, especially with dogs, the existence of a uniformly agreed upon market is not so certain at all. And although dogs are certainly bought and sold privately, publicly every day, as we know, their nature as living things that mature over time and change behavior over time, make their initial purchase price inconsequential very rapidly. The dog you bought at one date is a very different dog at a later date, depending on what you've been doing with that dog during that period. Dogs tend to do this strange thing, which is appreciate, not depreciate in value over time in light of the owner's involvement. Stranger still, and this is absolutely opposite to the way that we treat all other properties. An owner usually becomes less willing to accept value for the animal as the animal's value increases. The owner is less willing to impart monetary value to an animal at all over time. The St. Bernard that's been with the family for 12 years, it changes in a sense to become what they would call priceless compared to the very priceable St. Bernard that was just in the pet store window a day before. Okay, in examining all this phenomena, I decided to name my talk something about Scooby-Doo, so let's try and get to this well-known adult male Great Dane with some special dietary issues. The cartoon dog Scooby-Doo. He's a dog with distinctive individual qualities that might or might not serve as ownership indicators. Let's take a look at a few of them. Some are physical qualities, such as his wearing a blue collar with a golden-colored diamond-shaped tag that says Scooby-Doo. The fact he's often accompanied by a fellow named Shaggy carrying a box of Scooby snacks. Some are behavioral qualities, his favorable reaction to food, for instance, and his remarkable affection to those who offer it. Some are mixed qualities, ones that appear to be both manifest and innate together. His somewhat unhealthy startle response, for instance, seems to be a mixed quality, or his astonishing capacity for mimicking human speech. Given those indicia, and let's stick with those indicia for right now, what might the common law say about who owns Scooby-Doo? Is it the person who made his collar, or who fashioned the tag, or who purchased the snacks, or who carries the snacks, or who walks next to him, or who he licks after receiving a snack, or who palms him down? Shaggy, Velma, Fred, Daphne, even the corporate entity, Mr. Inc., probably all have a claim in that regard, but whose claim is the strongest under the common law? Although you might think it would be most helpful to know who initially bought Scooby-Doo, or who publicly claims to be his owner, you will find that those things make little difference at all to the common law. An examination of the common law on the topic reveals that it is current actions and activity. That's the test. Current actions and activity that determines true dog ownership. I know most of you in this room are dog owners. Many of you may be Scooby-Doo watchers, but all of you probably have some interest in the sense that you think to yourself, of course I own my dog. Who else would? That's how spooky things are going to get. I'm going to tell you who else would in a minute. This test, current actions and activity, starts from the unspoken premise that there are three fundamental distinctions between animals and all other personal properties in the eyes of the law. I've written about this before a number of times. I think I have it down in my handout. Mention it again. It seems to be important. One, animals have the ability to manifest intent. They can make decisions about things. Two, animals have the ability to move themselves about independently over distances. They can transport themselves. And three, animals have the ability to independently compound their value over time. I tell the students in my law class, to put your wallet or your handbag or your hamburger into a closet and close the door and hope you come back and you will not find anything more in there than the wallet or the handbag or the hamburger that you put in there. But if you put your dog into the closet and wait a couple months, and maybe it might take a couple dogs to put in there, but more will come out that you put in this magical thing called replication. Of course, animals certainly have the ability to do a lot more than just those things I mentioned, obviously. But I'm only talking about what the law finds interesting. Cars and houses, and handbags and hamburgers do nothing of the sort in that list. They don't act by themselves. They don't move by themselves, and they certainly do not replicate by themselves. But since animals do, we have grudgingly imparted to them special legal burdens and benefits to their ownership. The Burdens have both civil and criminal effects. We impose civil liability and criminal responsibility on the owner for any lack of care or harm to the animal, as well as for the animal's own harmful acts to others, including other animals. The benefits that we afford are some measure of the animal's value for its loss or its injury by another. Because animals make independent decisions and independently move themselves about the place and independently duplicate themselves, when the owner is dispossessed of an animal's ownership inadvertently, we don't treat animals by the same rules legally that we treat non-animal personal properties that have been lost or abandoned or mislaid. As you learn in law school, the rules about lost property, abandoned property, and mislaid property have very specific rules as to who's in priority and who's the owner, and does the finder have some sort of claim. With animals, we don't use those rules. We utilize the law of implied bailments instead, a whole different area. At the risk of boring you, I'm going to read you a quote from Long versus Noah's Ark, 2004 case from last year, or last spring, from Ohio. Talks about a lion cub and who owned a lion cub. Abandonment is a virtual throwing away without regard as to who may take over or carry on. No evidence suggests that the appellee left the lion cub without regard as to who may take over or carry on. Appellee stated that he entrusted appellant to take the cub to Noah's for temporary housing and care. Appellant testified that he had appellee's consent to take the cub to Noah's. Both men testified that ownership never transferred between them. Furthermore, appellee stated that he planned for the cub to ultimately go to Shambhala, which was a care facility. This is not the intent of someone who has no regard as to who would care for the cub. No genuine issue of material fact exists here. When appellee left the cub in Guard's care, he created a bailment. 2004, Illinois, the whole idea is bailment applies to animals. The current actions and activity test that determines true dog ownership relies upon those three qualities that is encompassed in those types of cases: intent, motility, and compounded value. It reflects an idea that whomever is an owner at one moment in time may change. There's my spooky part of my talk to you. A new owner may arise to take their place depending solely on time and circumstance. The spooky and astonishing thing about it is this: the legal machinery that reflects that transformation from owner one to owner two looks not only to the activity of the owner themselves, it also looks to the actions and activity of the animal. I know that doesn't sound fascinating to you, but I have to stop and think of that for a second. It's so fascinating to me. Let's apply this to Scooby-Doo and his interactions with the Mystery Gang. Because the actual possession and control of Scooby is often affected by his insatiable appetite and his anxiety level. He frequently does these things that we look at when we see animals. He manifests his intent to ignore commands or instructions by a presumptive owner. He just as frequently independently proffers his allegiance to another presumptive owner instead. Scooby may, for example, be under the direction of only that person who is themselves in charge of the Scooby snacks, or only that person who is actively running away from a hostile influence, as so often happens, or of that person who's merely resting comfortably in the back of the corporate vehicle. That person may at any given time be Shaggy, Velma, Daphne, or Fred, or even a third person altogether. Now, while I'm not saying that our common law holds that Scooby or any dog gets to determine who owns them, I'm not. I am saying that our ownership tests take into account activity by the dog as property that it cannot and would not take into account with any other piece of property. The common law folds into the equation the consideration that whatever a person might themselves have decided about their dog, the dog may have decided something a little contrary about the person, and the current actions and activity of people competing in their reaction to controlling a dog are what sets the stage for an ownership dispute, as I have to deal with almost every day. The first part of the Scooby-Doo effect, therefore, looks to what the potential owner is doing, not who the potential owner is. Put another way, the Scooby-Doo effect tends to reduce the importance of human status or position, and it tends to increase the importance of human conduct. Here's a quote from a recent Wyoming case, agonizing over who owns a horse, a child or her parents. 2002, Wyoming. Any property acquired by the child in any way except by its own labor or services belongs to the child and not to the parent. Common authority over personal property may not be implied from the parent's proprietary interest in the premises on which the property sits. Neither may it be premised on the nature of the parent-child relation. As a matter of law, the horse belongs to the daughter. The parents have no implied authority over it simply because of their proprietary interest in the premises on which the horse was located. Some lawyers get excited about cases. That case excites me in a sad way, I assume. And I get excited by a New Jersey case, also from 2002, that it talks about now not parent and child, but domestic partners, and whether a domestic partner, as opposed to a married couple, can assert an ownership in a dog. This is a case called Pippin v. Fink from New Jersey. While purchase and registration are significant evidence of the identity of a dog's owner within the meaning of the act, they're talking about a New Jersey statute, the actions, attitudes, and understanding of the suggested owner must be considered. Both Christine and Carol, the domestic partners, testified that they considered Zeus their dog. Their actions comport with the usual understanding of dog ownership by a couple. They shared the burdens and benefits of Zeus as a family pet, and they held themselves out to the world as the owners. Pippin v. Fink. The actions, attitude, and understanding that Pippin v. Fink talks about are vitally important to our concerns about ownership here. Holding yourself out to the world as the owner of a handbag or a hamburger doesn't require the participation of the handbag or the hamburger, but with an animal, it does. Some years ago, there was a horror movie starring Denzel Washington called Fallen, in which the antagonist in the movie was an invisible demon who moved from one character to another, taking over some people are nodding, taking over the person's body for a brief period before moving on to inhabit the next. It's a common theme in science fiction and horror movies, this idea that possession of the inner interests of a person may be at one and the same time both real and phantom-like. The Hidden, Invasion of the Body Snatchers, The Thing, 100 other similarly creepy tales all prey on threats that we may feel to our feelings of innate personhood or personal identity. The legal recognition of dog ownership accomplishes the same thing that that movie talks about. A slightly more positive spin, of course. Not just as a weight, but also as a reward. Does dog ownership possess a person, inhabit a person like a demon? Okay, that a dog may have several owners in its lifetime is no more a remarkable statement than that a car may have several owners in its lifetime. But you don't have to alter what you do and who you are to become and remain a car owner. You do with being an animal owner. That is remarkable. While an owner doesn't lose their rights to an animal just because the animal leaves their premises, People versus Castle, there's a California case very recent. An owner may lose their rights if they lose their care, custody, or control of the animal, regardless of where that animal is, on their premises or not. Even then, it may not be enough, for the animal may make its own independent decisions that are adverse to an owner's interest in remaining its owner. The second part, the Scooby-Doo effect thing, is this. Legal ownership in dogs itself is an apparition. It's a specter. It's a specter that's granted temporary legitimacy by the interaction of a dog and a person, not by a title or a deed or a sum of money or a piece of paper or a photograph or a blue ribbon. It's by interaction alone that it occurs. If you rest or pause in asserting your interest, that ownership may flit off you and onto the next vessel. You are not cloaked with it as a landed privilege because of who you are, a child or a spouse or a consumer. You are cloaked with it as a reminder of what you do instead, and as the joke goes, what have you done lately? Now the Scooby-Doo effect creates some unique animal law problems, among them the problem of the loan. I deal with this a lot as well too. The loan of any other property subjects its owner to zero legal risk. Since the act of loaning doesn't affect whether the title is strong or the deed is strong, it can't. The current actions and activity of the person to whom a dog is loaned, however, can easily affect the force of the ownership claim, and it often does. It's not uncommon for the phantom of ownership to inhabit someone who, under an earlier handshake deal, had simply been the caretaker for the pet, or had informally taken on the responsibility of someone else's pet, a friend, for instance, and yet spookily developed a new understanding with the animal based on time and some specific personal interactions. All the purchase papers, vet records, glossy photos, blue ribbons in the world will help the old owner reestablish ownership if the current actions of the dog and the caretaker speak louder than the former claimant's words. Loans of personal property are forms of bailment. Here we go back to bailment law. A bailment where it isn't a condition that's supposed to pass, but merely a specific period of time. Loans don't normally result in involuntary loss of the loaned object, otherwise people wouldn't engage in loans. But then again, most loans don't involve bailed properties that make their own decisions about where they like to be and when they like to be there. Many people who think that they bought a dog discover to their dismay that they actually bought only part interest in one instead. And many other people who think that they found a caretaker for their dog discover to their dismay that they actually found someone else a new home for their dog instead. In addition, the Scooby-Doo effect creates another animal law problem, at least an animal law problem to a practitioner, and that is reasonable valuation. As to Scooby's value to his owner or owners, that value must spookily change as each owner, with each owner as well by definition. The actions, attitude, and understanding of the suggested owner mentioned in Pippin v. Funk result in the complete extinction of any possible socially agreed upon common market for dogs. We don't have a dog market. We probably can't have a dog market because of what dogs actually are. The special value of each dog to each particular owner personally is really the only measure of compensable work. And there seems to be no consistent rules as to what indicia support that phrase. Oregon has the luck of having special value defined in a case. Chris already mentioned the site too, McAllister versus Sappingfield. I'll read you that part of the case that describes, at least in Oregon, what special value is. Property may have a value for which a recovery may be had if it is destroyed, although it may have no actual market value. It is not necessary in any case that there should be an actual market value for an article in order to entitle an owner to recover for its destruction. This principle of law has been applied in actions to recover for the destruction of a dog. The rule being, the owner of a dog wrongfully killed is not circumscribed in his proof as to market value, for if it has no market value, he may prove its special value to him by showing its qualities, characteristics, and pedigree, and may offer the opinions of witnesses. Okay, qualities, characteristics, and pedigree. I deal with that on a daily basis. I have to get jury instructions to a jury and have to help a jury figure out what to do about it. I have to convince a judge in motion practice very often what those terms mean, and McAllister versus Sappingfield being a 1914 case and having a number of cases after it, I don't get a whole lot of play with what other courts have done about that definition. Let's look at Scooby. He doesn't have just objective qualities, characteristics, and pedigree. He has subjective ones too, as all dogs do. Shaggy might claim that his appetite is unique. Velma that his size matters. Fred that his speech is noteworthy. Daphne that his affection is everything, and they might all be right. What would the common law under McAllister versus Sappingfield say about Scooby's value as opposed to his ownership? Well, who's doing the valuing and what's the agenda? Special value means different things to different people. Insurance companies would like special value to be tied to utility, in the sense of a dog being like a special tool or a special instrument. Only if the dog, like a furry machine, does some specifically useful act for the human, then will that group deem the dog to have compensatory value. Readers would like special value to be tied to reputation and notoriety in the sense of a special prize or a special place among other dogs. Only if the dog, like a sparkling window display, stands out among all other dogs in its appearance or in its breeding, will that group deem the dog to have compensatory value. And owners would like special value to be tied to personal feelings and emotions in the sense of a special connection or a special relationship. Only if the dog, like a child, privately exchanges love and affection, will that group deem the dog to have compensatory value. So who's right? Special value is highly phantom-like, as phantom-like as all the other ownership requirements. Okay, I mentioned all this talk about capture and actions and understandings and loans and value for another reason. The Scooby-Doo effect and the phantom of ownership suggest to me that those who wish to eventually alter the way the law views and treats animals as properties might do a little better taking small, careful, and procedurally justifiable steps toward that goal rather than taking large, careless, and intellectually unjustifiable leaps toward it. Legislation that simply proclaims animals to be our wards and us to be their guardians is meaningless wordplay in light of what real rules have developed over hundreds of years as to where we place civil and criminal liability and where we receive financial and personal benefit in our various social interactions. On the other hand, litigation that results in case law in which a judge or a jury has to recognize by evidence that animals and their owners have a relationship and then necessarily assign some effect and value to that relationship. That doesn't seem meaningless to me at all. Pearson v. Post, 2 centuries old, counting. The rules as to whom own animals and how they own them have barely been scratched, much less seriously challenged at the trial level. There seem to be no plans in the works for an international dog registry, nor would one pan out anyway, yet at the same time, I am not aware of any court that is planning on treating animals like children anytime soon. We see Jet versus Superior Court, California appellate case that says we are not going to treat animals like children, cites to plenty of other cases in the country that agree with them. The animal ownership phantom is not going to dissipate simply by proclaiming it to be gone, as the Guardian Ward designation does. The poltergeist of animal valuation continues to lurk behind every courtroom door. What these specters need is to be examined under the common law, not exorcised by statute. And the significance in the paraphernalia of owner-animal relationships needs to be embraced by 1,000 different civil and criminal cases until criteria are developed at the trial level that reflect what animals truly are to people. Ownership rights in animals are real legal constructs with lengthy historical origins. Animals themselves are natural objects, forming an integral part of the physical environment that we currently manipulate and have manipulated for hundreds of thousands of years. We cannot afford to engage in fantasies about them as we can with stars, and we cannot afford to be deliberately blind to their fundamental makeup as we can with cartoons. When we appropriate animals to our individual use, it's not solely as tools or as materials, although it is often that. Our appropriation has a social element to it, and it alters both the way that we look at the world and the way that we act in the world. What's wrong with a little decrease in the importance of status and a little increase in the importance of conduct? Why are we afraid of something? Okay, you might get back to it. I went a minute or two over, but Holly's going to...
I don't know if anyone here knows about the case of Speckles, the chicken in Southern Oregon, but this was a chicken living in the parking lot of a market, raised market, and the market, people in the market fed the chicken, and the chicken hung around. One evening, a man named Nick Gombos came by, took the chicken, saying, "This is a stray chicken, take him to my home." Built a coop, got other chickens to keep him company, etc. Raised Market called the police. The sheriff's department came to the Gombos' house, and Gombos gave them a hard time, so they got him for interfering with an officer and theft, I think, whatever charge it was. Took the chicken back to the market. Chicken continued to live in the market parking lot. In fact, Gombos just went to trial on the 6th. I don't know the outcome of October. Took the chicken back to the market. A few weeks later, a drunk young man came to the market parking lot, killed the chicken, and the Gomboses, I think they have a website now, and there's a whole thing going on down there in Southern Oregon. But I think isn't this an interesting case, and where would ownership be in the case of a market that the chicken was not confined, and this guy's being prosecuted for trying to take what he saw as a stray animal in, and the ultimate result was, of course, a tragic one. So what are your thoughts on this? Who owned the chicken?
As Groucho Marx would say,
This
are
was
you
all
asking
over
a
the
question or
newspaper.
making a speech? The question, but who would own that chicken in that circumstance?
The chicken was sleeping on a magazine, a news rack at night, and was being fed by employees in the market. So once this man absconded with the chicken and took him in as a pet, if you will, one of the employees called the sheriff's department, and the sheriff's department actually went out with 2 or 3 officers to the house and, said, we want the chicken back. It belongs to Ray's Market.
Holds themselves out to the world as the owner of a chicken seems to be a few characters you're drawn on. So in a sense, what the indicia of ownership is going to be with that chicken is probably based on even more facts than you're giving us now. I have a feeling we
Right.
probably all have to do like some sort of inquisition on a little bit of the history of the chicken, to the extent anyone would care to,
That's an
and a little bit of
interesting
history of
take.
those people. And it's going to be, my lame-o answer is it's going to be a fact dispute or a fact fact. I don't know. I'm not entirely certain who would own the chicken in those regards. To the extent that, is there some specific rule that would address that issue in Oregon? No, there's not. To the extent that indicia of ownership of chickens is different than it is with dogs, there's something said
Might be
there.
something else.
As market animals, there probably are market transaction elements you can probably show with a chicken. Farmers do keep, or ranchers or farmers do keep logs and inventories, and they might have a greater claim to ownership in the sense that they can show better history than someone who encounters in a parking lot. It's the best they got for you.
So it seemed to me you're saying at the end that you're a much stronger believer in using the courts to sort of hammer out this conundrum of ownership and valuation. Is that correct?
Yeah, no question about it. The common law is dynamic.
Okay.
And I love the dynamism of the word common law, and I don't understand Salem or much of what goes on down there, and it frightens me a little bit. And what I mostly like is bottom-up type of work through to the courts of review.
Because my worry and the stuff that I've kind of found, like, I don't know if you were around when we were talking about it, like, Florida's allowed sort of damages, civil damages for loss of a pet for, punitive and emotional damage for, 40 years. And all of a sudden you've got a judge just unilaterally decides to throw it all out the window and say, well, we're no longer going to allow, punitive damages against a veterinarian. And, New York has flip-flopped 3 or 4 times on it. It just seems to me there's so much uncertainty in the courts, and that's what is driving me towards seeking legislation to just get something locked in. Like, I agree that sort of specter, if you want to, if you will, of the guardianship thing of not being sort of ill-defined, but I think actually having legislation, say like Illinois, or even though it's not very effective, the Tennessee legislation at least has something there that's concrete that you can refer, you can kind of remove judges' sort of leeway, remove that from the equation a little bit more than you can now.
I love that uncertainty, and I thrive on that uncertainty. As I file, Holly knows this well, we file cases every day. And when we file a case and it goes into Clackamas County, and we think, oh, God, who are we going to get this time? And we bring the claim for loss of companionship or non-economic claim, and then the defense attorney brings a Rule 21 motion to strike it, and we go in front of whoever happens to be assigned, because in Oregon you don't get a judge for all purposes like you do in Washington. You get whoever is assigned on the law and motion docket that day. And so you get somebody, and they say, what, are you crazy? Non-economic damages for an animal? Not going to happen in my courtroom. Okay, you say, that's only the 10th time this month, so I'm all right with you. Then, the 11th time you go the next week and you get someone like Judge Redmond who says, I think there should be a new tort for pet owners. Actually, I kind of like this idea. Okay, motion to strike is denied. Go ahead, you can go to the jury on loss of companionship or non-economic. Great. That imbalance between what you can get out of one trial judge and yet what you can get out of another trial judge means that increases my opportunities to actually have something happen with kind of the spin of the wheel. I'm very much against a cap, as you were talking about, in part because plaintiffs' attorneys hate caps. But 25, what are you, crazy? What happens to my case that should be worth 50 or 75? Who knows that that's going to come down the pipe? But at the same time, I don't like statutes that limit procedural and substantive rights, and caps seem to do that. And the idea that some statutory restriction sits on me to prevent me from being able to expand a new tort theory or come up with some sort of new dynamic in the common law, I hate that idea. I hate being hinged on the statute. We were talking about vet malpractice as, in a sense, as that you got your professional negligence theory and that's all you have. I think the ability to have judge-made law decide that there might be other tort theories that might fit around that, breach of bailment or breach of implied contract, are things that you would never look to a statute to do that. You have to look to what the last judge in the other county just did. Well, I don't do it to just make them spend their cash, though. They can outspend me any day of the week, so that will never work very well. I mean, yeah, it hampers your ability to be creative. It's the only thing I don't. I get my suggestion. It sound like it fairly. My suggestion is that it's a definite benefit to the animal in the sense that there's this trend to try and move animals away from the property designation at all, which I feel is unfruitful and it's not going to work. There's also a trend to say, okay, within the property designation, let's make them special properties. That, I think, has a much better chance of success. The idea that ownership tests look to the animal as well to the owner, and no such thing occurs with any other property, seems to suggest that it raises the importance of the animal in the eyes of the law, even though it's a backdoor approach, right? It's not the approach which legislation says, animals shall hereby be of paramount importance. Now, what does that do? That's rhetoric on a Salem type level. But where the rule says, okay, you got to get a jury instruction to the jury that says they have to consider something about the animal as well as the owner, that does the same thing, only even more directly. So yes, the benefit of the animal. To the activists, you know, you'd have to give me a little bit stronger definition of what you mean by activists. I see activists all the time in different respects. Activists that want to eliminate the property designation, activists who, in a sense, are rescuers, who are like, pardon my French, we don't give a shit about the law about it. What we're going to do is we're going to take this dog away from an abusive situation. That's your, okay. The things can be beneficial and dangerous at the same time, and I agree with both. The rescuer calls me on the phone and says, we put the tape over the license plates, and we drove at night, and we got the dog out of there, and now what do I do? Well, you know, a couple questions, and I'm like, I don't want to hear about what you just did with your criminal activity about theft and trespass, but now that it's over with, and I don't have to worry about the professional obligation to report you to anybody, you know, and it's in the past. Now, what you're asking me, in a sense, is do I now own the dog, now having been, in a sense, a thief and taken the dog? Am I now the new owner, and what test is going to apply to me? And if that old owner who was abusive and neglectful and should never have been the owner in the first place, if they're going to come back after me, can I show that the reason why I should be the better owner is not because I have the better claim documentary-wise, but I got a better claim as being a better welfare person or a better guardian for the animal? That's what comes up a lot for me. And so then the idea is, okay, now, and sometimes, just simply to be an annoying plaintiff's attorney, I take the aggressive approach and we go sue the person who we just stole the dog from, just to make their life even more fun. And so not only are they the victim of theft, they happen to be the defendant in a suit, which is like, what happened to my dog? I was happily beating him the other day, and now someone's suing me over it. You know, what the hell was my point? There was something about that sounded really good, and I was almost there. But in any event, that type of fact pattern in which the establishment of ownership between the rescuer and the previous claimant, do these laws benefit that situation? Yes. That's my short answer to your question. I told you at the beginning of this talk, the thing that chills my heart the most, who owns the dog? That's the question. It's not, I don't have an easy answer for it, especially in backpedal you're presenting me. But that idea, I mean, it's a part of 100 children's stories. You know, the one child bends down, the other child bends down, and whoever the dog will come to, that's who the dog loves the most. You know, every crappy Disney movie you've probably ever seen in which the dog comes home after some long journey, it's the dog recognizes his true owner and woofily jumps through the air as the kid. Well, it's a little bit of a fantasy, but the idea is who was the one that was holding themselves out to the world as the owner, and who was the one that was actually taking active steps to do things, not just for the dog, but who was the dog in a sense acting as if it was its owner. Yeah, it's a Disney test, but in some ways it works a little bit better than the fact that someone says, I just bought this dog from Petco, 2 weeks ago, and then it ran away, and now it's running back. I don't care that it goes to the kid leaving through the air. It really is my dog because I purchased it. Yes, would work with the dog. Or sometimes does not. I think I cited you the case. Branding and marking is evidence of identity. It's not evidence of ownership. It's not an addition. What it does is identify that dog as opposed to a different dog. That's the best that's been 100 years of that kind of case law. You can print Joe on the dog's forehead with your branding iron, or I belong to Joe, in big hash marks or whatever horrible thing you want to do to the dog. It's indicia of identity. It's not an indicia that you actually have. Which one? Yeah.
Lose these cases very quickly, but winning them takes a long, long time because the other side constantly comes back and figures out how to do it differently, which is what's happened in this situation. In 1997, our firm was contacted by some groups who were concerned about this, and we wrote a letter to the administrator of NOAA, which is the agency, and the National Marine Fisheries Service, which are the agencies that regulate this type of thing. And that really sort of started the whole legal ball rolling. And the letter to them basically said, we now have learned that you have entered into this agreement with the Makah tribe without telling anybody that this is what you were doing, without soliciting public involvement at all. And our primary legal hook at that point was without engaging in any analysis whatsoever under the National Environmental Policy Act, otherwise known as NEPA. And as those of you familiar with that statute know, that's a law which requires, generally speaking, the federal government, when it takes an action, adopts a rule, does lots of different things to engage in a certain amount of environmental assessment. The government, though, had not done that at all, although they had entered into a binding agreement with the Makah. About 3 weeks after we sent the letter, the head of NOAA sent a letter back to us saying, you know what, you guys are right. We did forget to do that NEPA stuff that you talked about, but it's no big problem because we're going to do it now. And sure enough, they did it incredibly rapidly. About 3 weeks later, they cranked out what's called an environmental assessment. Again, if those of you know the NEPA process, that's sort of the first step before you do a full-fledged environmental impact statement. And it's the document you're supposed to put out to do a hard look at whether or not an EIS should be done. 3 weeks it took the federal government to crank out this draft environmental assessment addressing or purporting to address such important issues as the effect on the whale population, whether this was humane. The Makah were proposing, not surprisingly, not to hunt whales the way they used to, but this time they wanted to use 50 caliber rifles to go out and shoot the whales. As well as impacts, perhaps as importantly as all the others, in terms of precedent. One of the major arguments that we made and have continued to make to this day is if you open the door, this may not seem to many people as a big hunt, and obviously people in the location were concerned about it, but from the standpoint of the precedent would set, once you start allowing whaling on the grounds that this is a traditional subsistence whale hunt, even though it hasn't occurred for 7 decades, how many other of those kinds of activities are going to be resumed, and what kind of precedent is that going to be set for Japanese, the Norwegians, Denmark, and other countries that are looking for those kinds of opportunities. So 3 weeks later, they cranked out a draft environmental assessment. for public comment. There was substantial public comment on this from scientists and others raising all of these concerns. But before the final environmental assessment was even completed, they actually made a final decision that they were going to go to the IWC once again and propose the whale hunt to the IWC. This turns out to be significant when we get back to the federal court challenge we made. But at the IWC meeting, which took place in 1997, there was once again substantial opposition from countries around the world that said, we don't see how this falls within the subsistence definition. To deal with that problem, the U.S. government, your taxpayers at work, came up with a novel solution. What they did was they went to the Russians the day before it was going to be proposed, and the Russians had traditionally gotten a quota for their whale hunting by their. The other thing the treaty said, which was important on our side of the fence, was that these rights would be reserved in common with the tribe. That is, rights in common with the tribe and with other citizens of the state and the country. And so there was a question as to whether in common with, and I don't know how many of you have actually been exposed to treaty right language and this sort of thing, but there's a serious question as to whether in common with means that you simply can't deprive a Native American tribe of rights that others would have, or whether it provided a particular interest over and above what other citizens of the country would have. But in any event, fast forward to 1920, you can skip a lot of space in one fell swoop, because in 1920 is when the tribe, everybody agrees, around the 1920s, stopped to actively hunt whales. And then after a short period of time, they didn't hunt them at all for a long, long time. There's some disagreement about why exactly it is that the hunting stopped at that point. The explanations vary from the tribe's preferred explanation, which is that it was part of the U.S. government's effort at that time to civilize the tribe and to turn, quote unquote, and to turn the tribe more into a tribe that would be doing the things that the government regarded as useful and more in tune with U.S. policy. There were also some indications that over-harvesting, as it was referred to, or killing too many whales, was substantially reducing the gray whale population, and as a consequence, there just weren't enough whales to go out and hunt any longer. So it's not entirely clear what the reasons are, but there is no dispute that, in fact, in the 1920s, the tribe stopped hunting gray whales. And there's also no dispute that the gray whale population plummeted after that point, to the extent that when the Endangered Species Act was adopted, gray whales were listed as an endangered species for the first time. And also, during this period of time, the International Whaling Commission came into being in 1946, and domestic legislation was adopted that implemented the International Whaling Commission. I'm not going to go into a detailed exposition of that body, but it's basically an international treaty and an international organization that gets together every year to talk about how many whales should be killed and what kinds of protections should be imposed. It's got a lot of problems, as people may know who are familiar with that area of the law, but it will play an important role in this saga, as I'll address in a moment. In the mid-1990s, scientists began to feel that the gray whale population was recovering sufficiently to allow a hunt to proceed, to consider taking the whale off the endangered species list, and a number of entities, including the Makah tribe, petitioned the government to do just that. And in 1994, the gray whale was delisted. It no longer was protected by the Endangered Species Act. It did not take long after that occurred for the tribe to start engaging in discussions with the federal government to lay the legal groundwork for a resumption of whale hunting. And the record on exactly how that came into being is, again, a little bit obscure. There are some indications that the tribe was not acting alone, that it was having contacts in particular with the Japanese, who, as people may know, for many years have been trying to substantially expand their whaling activities, particularly commercial whaling, which has always been something the Japanese and some other countries, Norway and some others, and Denmark have done. And one of the ways that they were contemplating getting their foot in the door was to resume whaling by what was called subsistence whaling. That is, taking some tribes that could make an argument that they were engaging in subsistence whaling and that this was a traditional kind of focus, and using that as a way of getting, as I say, a foot in the door, and expanding that once that kind of traditional whaling was allowed to take place. And sure enough, the International Whaling Commission has always had an exception for what they refer to as traditional subsistence whaling. And no one has disagreed, at least on the international scale, that in fact if there's a continuing tradition, Alaskan natives being a prime example, Russian natives being another, if there in fact there was a long-standing tradition and clear subsistence need, that in fact would be a basis on which whaling could occur under the international approval process. The problem with the macaws case, as is readily apparent, I think, is that they hadn't whaled for 70 years. And so making an argument that this is traditional subsistence whaling is kind of a tough row to hoe, one would think. And even in terms of demonstrating subsistence need, it's a little difficult when, in fact, the tribe has been subsisting, for the last 75 years on non-whale products. Now, this didn't stop the federal government in the mid-90s, and one of the asides I would make is that there are certainly plenty of problems no matter which administration is in power. We yearn for the days when we had the headaches of the Clinton administration, but nonetheless, this was a Clinton administration initiative, and they sat down with the tribe and basically, pretty much in secret, because it took a while for people to figure out what was going on, they entered into an agreement in 1996 to actually promote the tribe's interest in resuming whaling. And they basically committed to doing a couple of things. They committed to going to the IWC and putting forth a proposal to the International Whaling Commission that the tribe be permitted to whale, notwithstanding the 70-year hiatus in whaling. The other thing they committed to doing was adopting regulations after that were to happen that would actually make clear that the tribe had a permission to resume whaling. And just to make clear that you know where I'm talking about, you guys are more familiar with this area than I am, but we're talking about the upper east-north tip of the state of Washington, which is where the Makai Indian tribe is. And there's a strait called the Strait of Juan de Fuca, which is out in that neck of the woods. And there's also the Olympic Coast National Marine Sanctuary. And in fact, this was a proposal to hunt the whales within the marine sanctuary, which is a long-standing marine sanctuary that, not surprisingly, says nothing about hunting whales and was not set up for that purpose. But that's actually the location where this was going to take place. In 1996, the federal government actually did, in fact, propose whaling for the macaw at the IWC meeting. But the proposal was withdrawn because many of the member countries, and this is not an international body which is known for its bravery and principled decision-making, but nonetheless, many of the member countries had a hard time understanding how this particular quota that was being requested could fit within subsistence traditional whaling. So as a consequence, the U.S. actually unilaterally withdrew the proposal. In 1997 is when our firm started to get involved in this issue. And again, one of the themes is going to be that if you actually have any success in these cases, you have to assume that it's going to go on for another 10 years, at least. It's good to get outside of Washington, D.C. and get a more balanced perspective on life. What I'm going to try to talk about is sort of the real-world role of using federal courts to advance animal interests. I'm going to talk about federal courts for two reasons. One, it's primarily what we do. We do a fair amount of litigation in state court, but the predominant kind of litigation that our firm has been involved in has been in federal courts around the country, frequently in Washington, D.C. That's becoming an increasingly inhospitable forum because of recent appointees to that court. If the election goes the way I suspect most of us don't want it to go, there's a serious question about the extent to which the federal courts will be a forum that one can seriously entertain for a lot of the issues that folks care about, and we can return to that. But the second reason I'm going to focus on federal courts is that In fact, the federal court system does afford some substantial opportunities for people who care about animals to advance animal interests. There is no such thing as a comprehensive, strong body of animal law that is specifically designed for animals. I'm sure everybody knows that, and I know one of the panels earlier today was talking about the weaknesses in the Animal Welfare Act and the need for a private right of action to make that law even marginally effective. But notwithstanding the glaring problems and the glaring weaknesses, which we all, I think, need to work on addressing, the federal court system nonetheless does afford some substantial opportunities. What I'm going to try to do is use two, what we refer to as case studies, two concrete examples of lawsuits that our firm has been involved in, that I've personally been involved in over the last 8 or 9 years. That's going to be one of the themes, is that if you get involved in one of these cases, be prepared to stick it out for a long, long time. And in which I think it's fair to say that we did accomplish many of the objectives that we set out at the beginning, although not necessarily in the way that we thought we would, and having, I think, won some or learned some difficult lessons along the way. So I think they do both provide some good overall insights into how to approach federal litigation to help animals and what that litigation can do and what it can't do. I would actually prefer that you now let me talk uninterrupted for the next hour, although I will if necessary. I will try to leave some time at the end for questions, but I think it would certainly be a more productive discussion if there are points that I raise that while I'm talking about them you think are not clear enough, or you want to make a comment about it. So please feel free to do that as the situation arises. The two cases I'm going to talk about, and I picked what I think are reasons of contrast and comparison. One is a case that I know has been of particular concern in this part of the country, and that is the macaw whale hunt that some of you may be familiar with, and that is the Macaw Indians tribe's effort to resume whaling of gray whales after many, many years of not doing so, and the interesting legal issues that raised. And then the other issue I'm going to talk about, or case I'm going to talk about, is the problem that afflicts manatees in the state of Florida, another marine mammal much further away, in terms of the vast increase in development and specifically the impacts from boats and development projects in manatee habitat. And the reason I'm actually picking these two, other than the fact that I think they actually are pretty good stories, is that they actually involve two different kinds of problems. One is a problem that is very focused, and by that I mean there's a specific initiative undertaken by somebody. The animal community is called in to do something about it, to stop it from happening. It's a very particularized kind of proposal or objective which is being put forth, and it's clear what the objective on the other side is. The other side's, that is our objective, was to stop it from happening. This is the macaw whale hunt. And defining success is very simple. Either you stop it or you don't stop it. I guess there was sort of some middle ground where you can mitigate it or ameliorate it in some fashion, but from the beginning it was clear that this was a proposal that was being pushed to resume whaling, and the objective we had was to prevent that from happening. The second one is a different kind of problem, and in some respects I think a more interesting one in the sense that it was really an effort to see if one could use federal law to address a large-scale social, legal, cultural phenomenon, and that is, and I should say actually economic phenomenon, which is widespread development in the state of Florida and how that's driving species not only to extinction, but as I'll talk about in a little bit, it raises actually very substantial animal abuse issues, because that's what happens to manatees in Florida waters. So they are, in fact, abused on a daily basis. So I think they have these two different kinds of problems, and you have to look at them somewhat differently, but I think some of the lessons pertain to both as well. So what I'm going to do is talk first about the macaw case, the more sort of specific objective situation. And then I'm going to talk about the manatee situation, and then try to draw some general inferences about what one can do with the federal court system in terms of animal protection and advancing the interests of animals. The Macaw case, and some of you may be familiar, again, with some of the background of this, actually dates back to 1855. I'm not going to cover in detail every moment of that period of time. But the reason I say that is because that's the year that the Macaw Indian tribe entered into a treaty with the federal government. And like many treaties that Native Americans entered into, it wasn't particularly fair to the tribe. But it did reserve traditional hunting and fishing rights in exchange for the Macaw, as was frequently the case, giving up a large amount of their territory. What the treaty said, which has become important over the course of the litigation, was that one of the specific rights that was reserved for the tribe was the right to whaling. And the reason why it's important is because it's actually the only treaty that anybody's been able to find in which whaling was specifically reserved to the Native American tribe. There are many treaties that refer to general hunting and fishing rights, and those can encompass hunting whales as well as other species. But this was the only one that specifically referred to whaling, which the Macaw Indian tribe, when they tried to resume their whaling practice many years later, pointed to that as an important factor.